We are going to start while waiting for the people to join. But, we want to respect those that have been on time. So first, let me thank you again. This is our last WBS Leadership Dialogue in 2021. So I'd like to thank you for being with us. And I know some certain people here have been faithfully following all our leadership dialogues, and I'd like to thank you for that. I like your engagement, your participation, and also some of you have come up with suggestions of how we can improve. Also like to thank our alumni who have made a call even through the public media on Business Day to continue to be part of us through this forum. And I'd like to thank the alumni that are participating and sharing with me, sending emails. Some of them, after they've seen the article on Business Day, they've sent me personally emails saying they're in and they're raising their hands. They want to be part of this journey of making WBS #1 in the continent and rank amongst the best in the world. That's the vision that drives us at WBS as the leadership team. And we live, we breathe that vision. And we are confident that we will achieve it. So thank you very much for those that have offered to help us. And our alumni office is going to contact you, and we'll have meetings, and then we'll be able to engage. So thank you very much. Thank you even for coming. I know all of us are busy, and it's already at the end of the year. There's a year-end fatigue, but you are here in your great numbers. Thank you very much. We are going to have this session today because of the very significant development in Companies Act that is happening in our country. We will unpack the amendments that have happened, particularly to understand what it means, what is the change. This discussion about these amendments has been taking time for a number of years now. And it's important if you're running a company, whether a small and medium company or a large company, even your own individual company, you need to understand what this Company Amendments Act is doing so that you remain compliant and also be able to do business properly. Obviously, this kind of question needs people with extreme amount of wisdom and expertise and experience who've been around. Who is that other than Michael Katz, Prof. Michael Katz, who doesn't need introduction in South Africa, especially in the area of legal matters, especially in matters of compliance, governance. Michael Katz runs ENS. He's been running it for many, many years. It's one of the largest legal firms. He's also a person who is not only just running a business, but playing a critical role in our country in policy frameworks, in developing legislative framework, and in developing regulatory framework, using his skills and talents and gifts to make this country a better place to be. With all the challenges we have, we need to have, I'm an eternal optimist. I know we'll go through all the challenges we have, and our children and grandchildren and great-grandchildren, we will leave them a legacy of a good country. And Michael is one of those people who is contributing in that space, particularly using his expertise in the field of law. I don't have to go through the CV of Mike because it will waste a lot of time. Let me tell you how the program is going to run. I'll give Mike 20 minutes to really unpack what has changed in the Company Act, and then really explain it so that at least it becomes an educational and informative session, so that all of us can be on the same plane before we start before we start the discussion. And thereafter, I will ask him a number of questions And in the meantime, while he's speaking, if you have a question, just go in a chat and put your question on a chat. I will see it, Mike will see it, and we'll respond to it. And then we will basically have a good dialogue for 1.5 hours. We will definitely finish in time exactly at 5:30, and that's where we are going to do. So that's a basic program that we have. Rutendo is here. Thank you, Rutendo, with your team. And we've got Dayton in case we've got technical challenges. We also have all our support infrastructure to support us in this webinar. So, Mike, I think I will hand over to you now. Go for it.
Thanks, Maurice, and thanks for a very kind and generous introduction. And it's really a privilege for me to talk on a WBS platform. WBS is very dear to me, so it's a great privilege to participate in this webinar on your platform. Thanks for inviting me, and thanks for the attendees' interest in coming. So what I'm going to do in the 15 or so minutes of introduction is to give an indication of the philosophical drivers of what is sought to be achieved in the Companies Amendment Bill. Now, there are 3 philosophical pillars, if I may, and that's how it's explained in the explanatory statement. And the 3 philosophical pillars are, number 1, to facilitate the ease of doing business. Number 2, to try and achieve equity as between executive management on the one hand and the shareholders and workers on the other hand. And then 3, to participate or facilitate the drive against money laundering and the finance of terrorism. So those are the 3 major philosophical pillars. There are also significant changes to the requirements to the Social and Ethics Committee, and then there's 1 or 2 purely administrative cleaning up issues. So let me start with the first philosophical pillar, and that is the ease of doing business. Now, it is fundamentally important for legislation to be clear, user-friendly, easily understood, consistent with established principles, and that is most important. A second, equally important, is to eliminate administrative burdens, unnecessary compliance burdens. And these are important. The objective of removing them is important for all business, but particularly for small and medium enterprise, because burdens of compliance operate most harshly against small and medium enterprise. It therefore is an impediment to competition and job creation. So the Act came into operation on the 1st of May 2011, but for 1 or 2 amendments before it came into operation, these will represent the first significant amendments. And what informed the ease of doing business amendments? This is new legislation. Like all other new legislation, errors inconsistencies, uncertainties are manifested in practice, and it needs a legislative response. Also, best practice in the world is changing, and that also needs a legislative response. So that's what informed the ease of doing business. Now what I'm going to try to do is to take you through those sections that relate to the ease of doing business. Then I will do the remuneration, the equity, and then the money laundering. So on ease of doing business, and I'm going to do it section by section. The first change is in section 1, a new definition of securities. In the existing Act, securities are defined as shares, debentures, and any other instrument, whatever its title or form. That has given rise in practice to some difficulties. For example, is a shareholder loan a security? So practitioners in the room or in the symposium need no further explanation why this amendment to section 1, the definition of securities, was necessary. And if the amendments are passed, a security will be defined as a share or debenture. The next important amendment in practice is the effective date of amendments to a company's MOI. What's been happening in practice is that amendments are sent to SIPC, and they're not always acknowledged timeously, dealt with timeously. The consequence is that people don't know when an amendment to the MOI becomes effective. The proposed amendment is that an amendment to the MOI will become effective 10 days after it is lodged with SIPC, unless within those 10 days it's acknowledged or rejected. So that's a deeming provision. And then there's a second deeming provision that if within those 10, that companies are entitled to put a later effective date. So the resolution amending the MOI might state that the effective date is 1st of January 2022. But the stipulated date in the resolution can't be earlier than the 10-day period that I've already referred to. Next, very important amendment is to section 26. Section 26 is the provision that allows access to company information to the public. And this has been a basis or a bone of contention for some time. And there are two sets of amendment to 26. One extends the scope. It now includes the company's access to the company's Securities Register and the Register of Beneficial Interests, but it only applies to public companies, state-owned companies, and certain private companies. It won't apply to a private company that does its financial statements internally, in an internal review, and it's got a public interest score less than 100, and it won't apply to a private company that does an independent review of its financial statements and has a public interest score of less than 150. And the reduced application of 26 is in recognition of the to try to ease the burden of compliance on very small enterprise and medium enterprise. The next important amendment is to section 30, sub 4. Section 30, sub 4, read with 30, sub 5 and 30, sub 6, deals with the disclosure of remuneration in the financial statements of a company, and the disclosure relates to directors and prescribed officers, what they receive in the very company whose financial statements we're talking about, or in any other company in the group of which they are directors or prescribed officers. What is the change to section 30.4 is that you can't now only say we pay this to directors or prescribed officers. You have to set out the name of each director and prescribed officer to whom the remuneration is paid. And that's designed to achieve enhanced disclosure, enhanced transparency. The next one is section 33. That's the annual return. And there is now a requirement to file with the annual return to the to CIPC the annual financial statements, and in addition certain other information, and the Securities Register and the Register of Beneficial Interests, a new provision in section 56, which I'll come to a little later. So the other important change to section 33, the filing of the annual return, is that it only applies to public companies, state-owned and private companies who are required to have their financial statements audited in terms of section 30.2 read with 30.7. The next important change is a new section 38A. This was necessitated by the fact that there wasn't brought forward into the new Act a provision that existed in the old Act, and this was a pure error, and that is what occurs when a company has an irregular allotment. So what this, the context in which this arises is that a company issues shares beyond the authorized capital. And because this wasn't regulated in the new Act, there has been endless discussions in practice. What is the remedy? How do you validate it? So now there is a specific provision to validate. An interested party can apply to court, and if the court considers it to be just and equitable, it can validate the allotment on such terms and conditions as it prescribes. The next amendment is to section 40.5. Now, in South African company law, the rule is, in section 40.3, that a company can't allot shares unless the issue price has been paid. The issue price must be determined by the directors, and they must be satisfied that it's an adequate consideration. If the directors have determined the issue price, the shares can't be allotted or issued until the consideration, the subscription price, has been paid. There's one exception to this, and this is section 40.5. And 40.5 allows the establishment of, I'm going to call it a trust for the moment, and the shares can be allotted to a trust for the benefit of particular beneficiaries, and will be paid to those beneficiaries when they pay the issue price. Now, this is a very useful section in empowerment transactions, for example. You don't have to resort to financial gymnastics with banks. Also for startups, you can have earnings that the dividends, you can put in that trust agreement that the beneficiaries are entitled to the dividends on the shares. So it's a very useful section in practice. The deficiency in its current form is that it refers to a trust, and that's given rise to concerns in practice whether the Trust Property Control Act and master approval is required. To eliminate that concern, the reference to trust agreements and trustees, and that has now been replaced with a reference to a stakeholder. So that is section 40.5. The next amendment that was shown in practice to be essential was the amendment to section 45 of the Companies Act. 45 deals with two different contexts. The one is the prohibition against companies giving financial assistance to their own directors or prescribed officers, or to directors or prescribed officers of any company in the group. That includes its holding company, its fellow subsidiaries, its own subsidiary. No amendments are made to that. Only the heading has been changed to reflect that there are these two separate changes, or two separate compartments of section 45. Where the amendment is to be made is to section, the other part of 45, which regulates the giving of financial assistance by companies intra-group. So when a company wants to give financial assistance to its holding company, a fellow subsidiary, or its own subsidiary, it needs a special resolution of shareholders passed in the last 2 years and compliance with the solvency and liquidity test. And the difficulty that's arisen in practice in this one, and where many representations were made, is that a company is precluded from giving financial assistance to its own subsidiary. This really has no rationale. It was a very big burden in practice with no rationale, and it is now, if the amendment goes through, it will eliminate the reference to a company subsidiary, which also includes a sub-subsidiary. The next amendment is to Section 48(8). Section 48 deals with buybacks, and the board of a company can resolve in terms of Section 48(2) to buy back its own shares. Subsidiaries can resolve to buy back shares in their holding companies, subject to certain limitations. And the current provision is that when a company resolves to buy back its own shares, then in certain circumstances, certain requirements are triggered. If the buyback is from a director or prescribed officer or a related party of a director or prescribed officer, then it needs a special resolution. Then buyback is more than 5% of the company's capital. The provision of 48(8)(b) says that the provisions, I'm not on the exact wording, of sections 114 and 115 will be applicable. Those are the provisions that deal with schemes of arrangement. And the difficulty that's arisen in practice is, first, if the buyback of more than 5% occurs on a stock exchange, then if it's incremental, which of the tranches triggers, then what is meant by the provisions of 114 and 115 will apply, and those concerns were appreciated, and it was thought that it is an unnecessary impediment to doing business. But what is the replacement? The replacement would be that if the buyback is from a director, from a prescribed officer or a related party of them, then it requires a special resolution. And in all other cases, it requires a special resolution, other than if it is a pro rata buyback, because that deals equally with all shareholders, or it's done on the stock exchange. The next one was to Section 61(8), and that deals with annual general meetings and the election of social and ethics committees must take place. There's now a provision for it to take place at the AGM, which wasn't there before. And there is provision for the documents that must be presented at AGMs, including the financial statements, the report of the Social and Ethics Committee, and the remuneration report under the new proposed 30A, and the Securities Register. They must also be presented at the AGM. The next one is the Social and Ethics Committee, some important amendments, which I'll deal with a little later. And then there's an amendment to Section 90, and the amendment to Section 90 is to make clear which companies are required to have an auditor, and it would be public, state-owned, private companies whose public interest score exceeds the amount determined under 30.2, read with 30.7, and a company in whose own MOI there is a requirement to have a auditor. Then there's an amendment to section 92. This amendment to section 92 was necessitated or became evident with the new requirement in the Public Auditors Act that there must be mandatory audit firm rotation. And what has become clear, and audit firms were very concerned about, is there are a limited number of audit firms with sufficient resources to audit major companies. And in section 92, auditors that have done certain non-audit work for a particular company cannot do the audit of that company for a period of 5 years. And there was concern that that 5-year cooling off period made it hard to find a replacement auditor with sufficient capacity to take over when there is the mandatory audit firm rotation. So the 5-year cooling off period, it's proposed that it will be replaced with a 2-year cooling off period. Next one is section 95, and in 95 that refers to share incentive schemes, and in the current act there's a deficiency. The only shares that are eligible are shares issued by a company or under which it has an option. But more often than not, the shares that are provided to or want to be used by a share incentive scheme are those that are purchased. So the replacement will be that the definition would include shares issued or purchased. The next important amendment is to section 118, and that is the jurisdiction of the takeover regulation panel. The TRP has jurisdiction over transactions, affected transactions, as defined in section 117, undertaken by a regulated company. And a regulated company is defined as a public company, a state-owned company, certain categories of private company where there's been a transfer of shares during the last, of more than 10% during the last 24 months on a running basis. The problem here, which has really been very clearly manifested in practice and never intended, is that there's an overwhelming load on the TRP, significant applications for exemption. And if we take one example that the TRP mentions, an attorney's office or an accountant's office forms a shelf company for the benefit of a client. The clerks in that company subscribe, and then they transfer the shares to the people who are intended to have them. That would trigger the 10% forthwith. So what is intended to replace this is that it would be companies with more than 10 shareholders and whose turnover or assets exceed certain limits prescribed by the minister. And the last one I want to deal with is section 135, and that's for companies in business rescue. And what has happened there is that a company goes into business rescue. It's a tenant of a landlord. In terms of the lease, the tenant is obliged to pay rates and taxes, water, electricity, and they don't do so. The landlord is precluded from instituting proceedings because they have the statutory moratorium in 133. So the landlord, in order to avoid the building being attached, pays that third party itself. And there were many representations that this is effectively post-commencement finance, and the landlord is really funding post-commencement, and the proposed amendment to 135 will recognize the situation for what it is. So, Maurice, those were the principal ease of doing business. Then there is the equity, the 30A, and then there is the fight against money laundering and terrorism, 56, and then the Social and Ethics Committee. I don't know how you would like. I'd need 5 minutes, 7 minutes to cover all of that, but I'll leave it to you. Maurice, you're on mute. Maurice?
I suggest we allow the engagement, because I can see there's a lot of questions on the chat, so that we zero in on the issues that people are very concerned about. So thank you very much for that overall overview. And I know a subject of this nature needs a lot more time, but let's move on. Let me ask you first one question. Thereafter, I'm going to ask questions from the chat. What are the philosophical underpinnings of this amendment bill? Just 2 or 3 that basically, I know you've said them at the beginning, but crisp, so that at least everyone is clear. What are the philosophical reasons? What's the philosophical rationale behind this amendment?
So
go for it.
As I say, Chair, there were 3 to eliminate concerns that have arisen in the implementation of the Act. Certain bad drafting, certain unintended consequences. This is the first real amendment since the Act came into force, and over time, submissions have been made, and most of these, there have been a plethora of submissions. So it was to eliminate burdens for small business, section 26, for example. So those were all to facilitate business, cure uncertainties, and the amendment to 30A, the new remuneration report, that was to give equity. There is a concern worldwide, and particularly post-COVID, of inequalities in society. And one of the concerns worldwide in many jurisdictions is that excessive remuneration at the highest level, by comparison with remuneration at the lowest level, exacerbates inequality in society. And then the third big philosophical is that there is the fight against money laundering and fight against terrorism. And that's where the necessity to determine the real owners of the beneficial interest in a company arose. And South Africa has been given 18 months to get its house in order in this. One of the poorer compliers, and the steps that are being taken in the amendments to Section 56 of the Companies Act are not limited to the Companies Act. There are other areas of legislation in banking and that where this fight against money laundering is occurring.
Let's go back to that question of remuneration disclosure. One of the, Adam Pike is actually zeroing on something very important here, talking about subsidiaries in listed companies. And he's saying, I want you to comment on this, is the disclosure, will it go to the subsidiaries? Because what, as Adam says, the most highly paid individuals are hidden in the subsidiaries, away from the gaze of the regulators. Just give me your comment on that question from the Adam Pike. Thank you very much for that very, very insightful question, Adam.
Okay, so to answer Adam, 30.A is the new remuneration policy and the remuneration implementation. But there is section 30.4. 30.4 read with 30.5, read with 30.6. And in the annual financial statements of a company, there must be disclosed in any particular company what the director or prescribed officer receives from that company and from companies, if you look at 30.5, from companies in the group. So I think, I'll look at it more closely, but I think that you don't only look at the new 30A to see what a particular director is, the remuneration they're getting. If you look at 30.4, read with 30.5, read with 30.6, it should capture the totality of the prescribed officer's remuneration or director's remuneration from companies in the group.
Okay, so there's no hiding place, if I'm hearing you. And then Alexandra has asked another very good question. He said, look, there are companies which do not require to have audited financial statement, and they do so voluntarily. But if they do so, do they also need to file this annual financial statement and the additional information while filing the annual return?
Okay, so
Alexander is asking. Thank you for that question, Alexander.
Section 33, the annual return, is applicable to companies, state-owned, public, and companies who are required by the Act and regulations to have their financial statements audited.
So
if they're not required, then they don't have to file that with their return.
You got your answer there. Adam is still not very convinced that this amendment is going to help ease business doing a business, because it says JSE rules still requires an expert report and a special resolution. What's your comment?
But if you're talking about JSE rules, and you're talking about a company, then I'm not sure when you're saying it's a voluntary audit. It's a compulsory audit.
No, it's compulsory. It's definitely. JSE rules are there. You have got no option.
That's the Companies Act. If it's a public company, their financial statements must be audited. So there's no voluntary audit there.
Yeah. Well, JSE has got rules. Yeah.
The Companies Act requires.
Yeah. No, you're right. What I'm just saying, Adam, is that once you're on JSE, you've got to follow the JSE rules. There's no chance about that. I think Seppo has got a question there. He says, Michael, isn't it ironic that the amendment bill has as its philosophical pillar the promotion of the ease of doing business, but it continues to require companies to lodge annual returns together with Securities Register and Register of Beneficial people. So, but that's the reality. That's what you're saying, yeah? That, Mike?
Well, with respect, if I can answer that. Many people say that a company is a private organization. Isn't this an intrusion into privacy? There are two judgments of the Constitutional Court, and I just want to read. One is a case of Bernstein versus Vesta in 1996, and the judgment is, the establishment of a company as a vehicle for conducting business on the basis of limited liability is not a private matter. It draws on a legal framework endorsed by the community and operates through the mobilization of funds belonging to members of that community. Any person engaging in these activities should expect that the benefits inherent in this feature of statute will have concomitant responsibilities. These include, among others, the statutory obligations of proper disclosure and accountability to shareholders. It is clear that any information pertaining to participation in such a public sphere cannot really be held to be inhering in the person, and it cannot consequently be said that in relation to such information, a reasonable expectation of privacy exists, nor would such an expectation be recognized by society as objectively reasonable. And then when Sir Sidney Kentridge sat as an acting judge of the Constitutional Court when it first came into being, he emphasized in State versus Kutsia that, quote, those who choose to carry on their activities through the medium of an artificial legal persona must accept the burdens as well as the privileges that go with their choice. So what not that there's no regulation, but there isn't unclear, unnecessary burdens that don't have a rational basis, that don't afford protection. So no one says there shouldn't be regulation. It should be clear, user-friendly, understood, properly drafted, and have a reasonable protection of stakeholders in mind.
Yeah, there's a lot of engagement. Please send your chat questions. Albie is saying, Albie Celius is saying, is SA Companies Amendment process also in line with global best practice in this regard to transparency, and particularly in relation to identification of lobbyist input? Wow. And we know that in America in particular, the lobbyists are very active. This is not yet a big industry in South Africa. But is that transparency that needs to be reflected there? I don't know how it's going to be reflected. I'll leave it to you, Mike, to answer that question.
I'm going to try and answer it.
Yeah.
The first part, in the advisory committee, one does try to have regard to international best practice. Where is international best practice? What would be the source of it? Legislation and case law.
Yeah.
So one would look at those as the source of international best practice. Now, lobby, with respect, I think the whole issue of lobbying, etc., clearly not as profound or advanced in South Africa as in the US, for example, but our entire parliamentary process is designed to be transparent and to have adequate opportunity for interested parties to be heard. So, for example, all these acts of parliament have to go through the relevant portfolio committee. And there's opportunity for people to make submissions.
There's a question here also around non-profit companies, private companies, people really getting worried about their confidential information landing in the hands of competitors or also contractual counterparties. This is a concern that people have. What's your thought around that?
Okay, once again, and I refer again to Bernstein versus Bester and the judgment of Sir Sidney Kentridge and State and Kutsia. When you carry on an activity in an entity,
yeah,
that's not a license to have an opaque body that can be doing crime, can be doing deleterious activities. Once it operates in the public domain, it's subject to transparency and regulation. So I'm not sure that there is a legitimate concern, and the idea of being competitively sensitive. Those arguments have been made to legislatures all over the world, and I don't think that there's any traction. There's hardly a developed economy that doesn't have the same degree of requirement of transparency that we would have.
Great. There's also an issue that is worrying people. Is this illicit cross-border trade and behavior? Will this kind of amendments also be able to curb this and make sure that people comply with the regulations in that space?
Okay, so let me just I should have made one observation on section 30A and the remuneration report. That's not prescriptive, it's disclosure. So no one's saying how much a company can or can't pay an executive. Just disclose what you're doing, and then your shareholders can decide what they want to do or don't want to do. So now we get to section 56, this Securities Register. And as I say, South Africa's behind the curve. We've been put on notice by the various international bodies that we must get our house in order, that our requirements on determining the true owners of companies, the holders of beneficial interests, is defective. So what one wants to achieve, and whether the proposed amendment achieves it or not, obviously, it's a very difficult thing to determine who really owns the beneficial interest in a company, with nominee holdings, with trusts, with spider web organogram. Very, very difficult. But I saw someone the other day made a submission. Disclosure of beneficial ownership enables the state to fight financial crimes and aids the public in assisting with that fight. This is not only good for the public, it is also good for business. Corruption impairs the economic performance, competitiveness, and investment climate of a country. This is not conducive to an enabling business environment. Access to beneficial ownership information also facilitates fair competition and due diligence, both of which are good for business. So what's designed is to establish really who is behind this company. Not who is the registered holder. So who is the beneficial? Various steps have been put into 56. I wouldn't suggest for a moment that that's the end of the matter, that people won't still be able to overcome this, but it's a step in that direction.
Thanks, Mike. I think his illicit cross-border activity is very dangerous for our economy. Colin is concerned here in, say, disclosing the remuneration pay gaps in particular, as you indicated earlier on, the pay gap between the CEO and the lowest person is pretty high. And therefore, particularly in Africa, the issue of inequality is a big issue. But her concern is that, will this not hinder foreign investment rather than encourage it if we disclose these paybacks?
Okay.
What are your thoughts?
With respect, if you have a look what's set out in the explanatory statement, what's happening in England, Australia, USA, this concern about inequality in society is worldwide today. There are people who are saying that it's the biggest challenge to capitalism. Inequality in society is a huge concern, and that was exacerbated in the COVID environment. So one of the concerns contributes to that inequality is excessively high remuneration at the top and a significant gap between at the bottom. So is this going to change anything? Will it make a realistic contribution to reducing inequality in society? Well, I don't know, but there are two reasons why it's expected that it would. One, shareholders have now got a much better idea of what the true position is. And they can, this is not prescriptive. It's not telling people, companies, how much they can and can't pay. All it's saying, you must disclose it and get it approved. So it will arm shareholders. The second thing, all these disclosure mechanisms are designed to what's called have the shrinking effect in prospectuses. From early days, when promoters were obliged to disclose their commissions and that, they would be embarrassed in their circles. How could you receive so much for that? So they took less. It shrank. It had the shrinking effect. So when people in a company where the lowest paid is getting minute in relation to highly excessive, it may have a shrinking effect. People may be embarrassed with that. So those are the two objectives of this kind of disclosure.
Yeah. That leads me to this question of shareholder activism. The first time I experienced it, it was pretty traumatic because, in the past, the AGMs were 30 minutes, at most 1 hour, but I attended the AGM, which lasted for 5 hours because there was a lot of shareholder activism there. Is this bill facilitating and promoting? I suppose so, but just unpack that a little bit in terms of shareholder activism.
Okay, so with respect, Maurice, the bill is only some amendments to the Act. You must look at the totality of the Act, whether shareholder activism is facilitated. So the biggest mechanism, the ultimate shareholder activism, the ultimate result of shareholder activism is the replacement of the board or directors. Section 71, one of our Act, is the ultimate in shareholder democracy. Any director, notwithstanding the MOI, any rules, any resolution, any agreement between the shareholder and the director, the shareholders who elected a director are entitled at any time through requisition of a meeting without cause to remove. So a simple majority can remove a director at any time without cause. So that's the ultimate shareholder activism. Where will the bill promote activism? Where one of the biggest elements of activism today, and we saw in a company yesterday, is voting down excessive remuneration. So anything that requires explanation of policies and the implementation to that extent promotes activism, that portion of activism.
That's very good. That's very good. Which leads me to the question about social and ethics committee, which you wanted to comment on. Let me give you a time around that, because it's important that we understand how this amendment bill is impacting the social and ethics committee.
Okay, so let's just talk about the social and ethics committee conceptually.
Yeah.
Interestingly enough, South Africa is the only company in the world that has one.
Wow, that's great.
We have been recognized, we have been lauded, praised in many circles. So in 2012, I was part of a project, the special representative of the Secretary General of the United Nations, Professor John Ragi, who unfortunately passed away in the last 6 months. He did a report, and there was a project. I had the privilege to be part of it, on the link between corporate law and human rights. And we were heavily praised in that project for the Social and Ethics Committee. Professor Lynn Sharp-Payne, a very prominent professor at Harvard Business School, did a specific project on South Africa's Social and Ethics Committee. So the Social and Ethics Committee has been praised worldwide, and that would be the ultimate watchdog on the company's compliance, on its ethics. And today we see the huge attention to ESG, environment, social, governance, where you will see that manifested is in the work of the Social and Ethics Committee and in the report of the Social and Ethics Committee must give to the AGM. So that is a very, very important concept in the South African Companies Act. Once that's the starting point, let's see what's happened in practice with it. And there have been significant debates at NEDLAC between business and labor, and what is necessary to really beef up the social and make it more effective. So there are some bread and butter amendments that are proposed. For example, a provision for an application for exemption in terms that 72, the proposed 72.6 will allow an application for exemption from compliance with Social and Ethics Committee to be made to the Companies Tribunal. And the Companies Tribunal could grant it if there is another structure in the company that does the work of the Social and Ethics Committee and it's in public interest to do so. So now, who will the companies bound by Social and Ethics Committee? Public companies, state-owned, and private companies whose social interest score, public interest score exceeds 500 in terms of 32, read with 30.7. So those companies are bound unless, one, they get an exemption, or two, they are a subsidiary of another company that has a Social and Ethics Committee, and that Social and Ethics Committee also does the work of this one. Then there are provisions for how it's appointed, how it's elected, what should go into the report, and what should be the sanction for non-compliance with the. So that's really what's intended. The one observation I do want to make is that an external company or a foreign company that carries on business in South Africa, that doesn't have to have a Social and Ethics Committee. By and large, the South African Companies Act only regulates companies which are defined as South African incorporated.
Okay, there's a lot of activity on the chat, but let me ask you this question about independent auditors and the cooling off period. What adjustments has been made so that we just amplify them again, so that we're clear about the independent auditors and the cooling off period?
So what highlighted the necessity for this?
Yeah.
The audit profession was very concerned because in terms of the amendment to the Public Auditors Act, there's now a mandatory audit firm rotation.
Yeah.
So big companies who need well-resourced audit firms with capacity, when their audit firm's rotation occurs, they've got to get another big company to do the audit. And in terms of 92, any other potential audit company that in the last 5 years has done non-audit work for this company, such as bookkeeping and various activities set out in 92, they are disqualified.
Yeah.
They did that work in the last 5 years. So the cooling off period will come from 5 to 2. So
Okay.
the disqualification is much more reduced.
Okay. All right. I think that's absolutely clear. There's a lot of activity. Alexandra is saying, you know, there seem to be, yes, you can remove a director as a shareholder. If you're unhappy with it, you don't have to give a cause. But the CIPC still requires you to provide reasons in order to remove the such director. Is there alignment there? I guess what is Alexander saying? So,
with respect, when shareholders wish to remove a director in terms of 71(1), in terms of 1(2), they must give notice to the director whose removal they seek and give an opportunity to be heard. So the reason doesn't see 71(2), you need to give the opportunity, the audi alterim, before the shareholders of the company may consider a resolution contemplated in 1. So 1 says, despite anything, they may be removed by an ordinary resolution adopted at a shareholders meeting by persons entitled to exercise. And then 2, the director concerned must be given notice of the meeting and the resolution at least equivalent to that which a shareholder is entitled to receive, irrespective of whether or not the director is a shareholder, and the director must be afforded a reasonable opportunity to make a presentation in person or through a representative to the meeting before the resolution is put to a vote. So what the questioner is asking, the Act doesn't specifically say in the resolution, give reasons, but ordinarily the purpose and effect of a resolution is in the notice, section 65(4), I think, you must specify the purpose, etc. So if you read them together, I think it would answer the questioner's question.
No, I think it's clear. Obviously, you have to give reasons, and they're the same reasons that you will put on the CIPC when you do remove the director. It seems to me, Mike, with these amendments, and then guide me here, in the past, it used to be quite a status symbol when you're invited to serve on a board of directors. But with all these amendments now, it's more of a risk to assume the role of a director. What's your thought of that?
Okay, what I'm going to do, Chair, is quote from a judgment of the Australian Federal Court in a very famous judgment that is the locus classicus today of directors' duties in approving financial statements.
Yeah.
It was an Australian case of Australian Securities and Investment Commission versus Healy. And in that case, the Australian Securities and Investment Commission sued the entire board and officers of a company for approving financial statements that were defective. So it was a very significant case, and I really commend it to people who are attending this. So the judge said the following, it was on this, it's too burdened to be a director. So the judge says, this proceeding involves taking responsibility for documents effectively signed off, approved, or adopted by the directors. What is required is that such document, before they are adopted by the directors, be read, understood, and focused upon by each director with the knowledge of each director has or should have by virtue of his or her position as a director. I do not consider this requirement overburdens a director, or, as argued before me, would cause the boardrooms of Australia to empty overnight. Generally well remunerated and hold positions of prestige, and the office of director will continue to attract competent, diligent, and intelligent people.
Diligent, competent, and intelligent people. So you're going to make sure that
answers the question.
Let's come back to this issue of ESG. It's actually becoming quite a tsunami in the board. What's your take after COP26 that has just finished now? Particularly for now I'm coming from the energy background, so I'm going to ask this. Are we going to see quite a significant pressure point from COP26 on the whole issue of climate change and sustainability, and directors needs to take a very considered view on this matter? What's your take on that?
So, Chair, what's interesting is how important this has become. And if you see guidelines, I'll come to COP26 in a minute. If you see some of the guidelines in America today, and SEC, and attorneys' firms, it's becoming a core function of directors to have structures in place to deal with environment, governance, social, but it is a core function today. And what's interesting, Chair, is if you have a look at asset managers are refraining from investing in who they don't consider to be ESG compliant. And what is all this resulting in? Auditors, new accounting standards are coming out and telling that your financial statements must reflect the cost of compliance with ESG and non-compliance. If you see some of the latest audit standards dealing with ESG, because one of the big concerns has been, how do you measure compliance with ESG? And there have been books written, and one really very good one is Reimagining Capitalism by Professor Rebecca Henderson. And she's got a whole chapter on the accounting requirements so that shareholders can decide whether they wish to be in that company. And it's interesting how many companies today, not only banks, but won't invest in a fossil fuel company. So I think the pressure on ESG is on boards is going to become huge. Disclosures, and I think the activities of the Social and Ethics Committee in responding to this is also going to be huge.
Just one last question for me. I think I'm asking on behalf of young directors that are coming through, is if you made a decision now and you serve on this board and then you retire and in your late 80s and you've left the company, will the decision that you made and it's found wrong now because of either ESG or environmental challenges, contamination and all those kinds of things, can you be hauled out of your retirement and be held accountable, because it seems accountability is a big issue in directorship now.
Okay, so there are few criminal sanctions in the Act, and the civil sanctions, most of the duties are owed by a director to the company. Section 26, which sets out, codifies, quote unquote, the common law duties of directors, those are owed to the company, and only the company itself can sue on it, or a shareholder derivatively. There are some occasions where shareholders have direct rights to sue, section 218(2), and in very few cases on reflective loss. But then there are the prescription periods. So a person who retired at 60 and is now 80, I don't think that should be the person's main concern.
Okay, good. We're coming closer to because I really respect time. And Mike, I want to give you an opportunity to just give your concluding remarks around this massive change, and also explain the process now. We know that the public comment closed on the 1st of November, and how's the process going to go going forward, and what do we need to expect in this process? I know that we've had this seminar, this webinar, but we're going to put it in the public domain, even if the public comments have been closed. Definitely what is in the public domain, I'm sure the relevant authorities will read the comments which have been made here.
So, Chair, as is the case with all legislation, and I'm not giving you precision here, the comments must go, the government must consider it, it must be approved by cabinet, it must be approved by the state law advisors, whether it's constitutional, whether it violates any constitutional requirements. If all of that is done, then it will go to the appropriate portfolio committee in Parliament and will follow the normal legislative process.
Do you want to hazard your guess in terms of the timing?
Don't have a clue, Chair.
I don't want to put you in that spot, because the rules of government sometimes may not go as fast as you would like. So, but ladies and gentlemen, and all the participants, there's a major changes in our Company Amendment Act. And please, I think it's better to be proactive about this and make sure that you prepare your companies, your governance structures, and your compliance structures, and educate people around it. And we at WBS are quite keen to assist you with understanding even more. You're welcome to drop us an email or anything like that. We will continue to make sure that if it means putting a course together through our own big infrastructure we have, whether it's Wits University or short courses, we will be more than willing to do that, so that by the time the act comes, your company is ready. So on that note, I would like to thank Mike. Again, Mike, I would like to thank you for all the time that you give us. Even Adam Pick is saying very informative. I have a better insight into the effective drivers of the amendments. So people have benefited and actually understand it a little bit more better. So thank you very much, ladies and gentlemen. Stay safe, stay healthy. And I'm not forcing anybody here, so please don't ask me don't sue me here and say I'm forcing people, but I would definitely encourage you to go and vaccinate because we need to get our economy going as quickly as possible. I have done my vaccination to 2 of them. And if there's a third booster, I will definitely go for it. So I would like to encourage all of us. So stay blessed and stay healthy. Thank you very much.
Thanks, Chair, and thanks for giving me the privilege of your platform.
Thank you.